You're on the record, Judge.
All right, good morning. This is case D530134, Ryan Geraldo versus Andrea Gultierrez. Let me get counsel's appearance, please, for a defendant.
Good morning, Your Honor. Megan Shigemitsu, bar number 14618 from Gandhi Dieter Blackham, on behalf of Andrea Alessa Gultierrez, the defendant in this case, who's appearing by separate Blue Jeans link, and she goes by Alessa.
Okay, thank you. And I have the plaintiff available as well. So this is back before the court on motion filed by mom to again consider modifications. This time the strategy is to ask for modification to visitation, reserving the right, whatever, frankly, I'm not sure what that means, but reserving the right to argue for a modification of custody. I suspect it's sort of a let's see how things are going, and then I'll decide if that's something that we're going to pursue. It is not true that the court does not need an evidentiary hearing and to modify visitation. I do. Gordon v. Geiger says that the court cannot make changes that impact the custodial parent's time in favor of the non-custodial parent without an evidentiary hearing. So whether it's a modification of visitation or a modification of custody, the only way these things get resolved is through an evidentiary proceeding. Utilizing the party's resources and the court's resources to have an evidentiary proceeding for visitation or even custody related to a 16-year-old, which he'll be in just a couple of months, seems like an extraordinary waste. I'll be perfectly honest with you. And more than the circumstances concerning your son, it is reflective of the party's ongoing inability to accept the circumstances that they find themselves in, take responsibility for the circumstances they find themselves in, and an unwillingness to extend any sort of grace whatsoever to the other party just by virtue of the fact that that other party is a parent to your 16-year-old son, along with other children that are no longer under this court's jurisdiction. This case frustrates me beyond belief. What the two of you have done to your children is inexcusable, and you're not going to stop. 16 years old, and you're not able to stop this. I am not concerned, counsel, with whose fault this is. They are both to blame. If you want an evidentiary hearing, I'll give it to you. Dad tested positive for drugs. Mom's raising that again as a basis to modify custody. It's not. I was satisfied with the information given at the last proceeding regarding the drug use. I confirmed again for my own information today, based upon ATI guidelines, that his drug use is consistent with prescription drug use. I will order him drug tested again today so that we can confirm his levels are consistent with prior drug use or prior prescribed drug use. And he'll have to supply the prescription drugs to ATI when he goes there. I'll give you a deadline, sir, of when you need to submit today. I guess what ultimately frustrates me most of all is that whether I grant an evidentiary proceeding and these parties spend the time, money, court's resources to conduct an evidentiary hearing, or I just deny it outright today, I haven't heard the end of it. There's still 2 more years, and I suspect both of them will find plenty of reason to refile motions in front of this court, whether they have any value or merit, or whether they are in the best interest of their son or not. And if either one of you thinks that this speech is directed at the other party and not to them, you're wrong. This disdain for how the parties have conducted themselves over the lifetime of their litigation extends equally to both of them. Period. So, counsel, I'm not making any changes today, not one. If your client wants to pursue an evidentiary proceeding, I will set a discovery schedule and we'll go to trial. The child will probably be close to 17 by the time that happens, but we can keep fighting.
Your Honor, since I was not, I have reviewed the case history extensively coming onto this case. I was just retained when I filed the underlying motion, but I think it would help for clarity purposes because I'm confused about the position of the court because there was a situation in 2018 and 2019 regarding Alicio's health and into 2020, and there was statements in the orders that he would be with dad primarily for a basis to get his gastrointestinal issues and diet and with consistency, and it was right in the order that it was presumed about 6 months out if he stabilized and he would be older and more mature and able to articulate his needs, that mom would then be able to possibly have additional visitation. She did come before the court unrepresented prior to retaining counsel with our office, and she filed a motion to modify to seek sole legal and sole physical custody, which was denied outright by the court. So that's the basis for the underlying motion, is that I felt as an unrepresented party she had asked for something that was not tenable and it was not properly pleaded. But it seems clear to me from the court record that once Alicio became more stabilized, that it was anticipated that it would be considered that mom would have more than 1 day a week of visitation. They used to have joint physical custody. I understand there's a very complicated and long and litigious approach to this case by both of them, though certainly in recent, for this underlying motion practice, I feel the requests have been reasonable, the concerns have been well substantiated, and Mr. Geraldo has filed numerous unmerited repeat motions, which we have not. I did file a motion to strike the first 1 or 2 of them, and then he kept filing them. So I don't think that they're been the same with their approach, at least in the recent actions. But that's really where we're coming from, is we're just trying to get some temporary visitation so that she would have more than just 1 day a week with her son, especially because he is turning 16 next month, Your Honor, well, in November 1st, I believe. And, Ms. Gultierrez has tried repeatedly to have just additional visitation with him, and she has not been able to get Mr. Geraldo, which is, I think, evident from the way he handles this case, the pleadings he has filed, their social media posts. It is quite clear that he is alienating Ms. Gultierrez and not making any efforts to allow her additional time with Alicio.
Well, first of all, the only exhibit related to their communication asking for additional time out of the 108 pages or more that the court reviewed that were submitted by mom, there is one text message. She says, hey, I want extra time. He says, no, we're sticking to the order. Him insisting that they abide by the order, especially in a contentious case like this, is not problematic for the court. There is substantial evidence of mom's ongoing alienation of the children from their father. She speaks negatively about him. She has nothing to say that's positive. The children have tried to stop her from talking to them about their dad. Again, this goes both ways. I am not blaming one more than the other, but it is also not true that your client is blameless in this situation. This has been a litigated case. You've acknowledged that. There were substantial findings made. And I'm going back. This case started, I have to go through pages and pages and pages of court summary. There are 58 pages for a case that started in 2015. 58 pages of litigation between these parties. And they are not 1 inch closer to being able to deal with each other respectfully. That's where the frustration comes from, counsel. I've only been on this case for 1.5 years and have already had way too much of these parties. And the parties learning how to deal with one another. It's hopeless at this point, to be honest with you. And once I get to the end of the 58 pages, I will tell you when the court addressed the concerns that you're raising right now. In March of 2021, the court responded to those concerns and increased mom's visitation, consistent with the order that was made by Judge Gentile, acknowledging that their son was not at risk the way that he was initially, and that Judge Gentile anticipated an expansion of mom's visitation. The court did so to the extent that was appropriate at that time. So it's not that mom, as an unrepresented party, has come before this court and the court's ignored her concerns. I've addressed them. I've addressed dad's drug use. I've addressed these parties the same way I'm doing today at prior hearings, letting them know that this is unproductive.
I understand, Your Honor, but there was subsequent orders from April of 2021 and July of 2021 when Mr. Geraldo tested positive for drugs, morphine, oxycodone, and hydrocodone. The court asked him to provide proof of his prescriptions, and he did not. And then in July 27th of 2021, Ryan did not appear for his drug testing and then tested for BUP the next day. And the court noted that this was used to treat his opiate addiction, but that it still had concerns about the levels and his history and use of drugs, and advised that it was inclined to refer the case to CPS. That's the court records that I reviewed. I don't know what happened with the referral to CPS, and it was also stated in that July 2021, so that's that's after the order you just mentioned, Your Honor, that mom was self-represented and the court told her to file a motion. And that's when she went forward and filed the motion in January of 2022, which was for sole legal and sole physical, which I fully acknowledge was not legally the right request. And she didn't have any counsel back then. So, but it certainly seems to me like there's been cause for concern since March of 2021 that merited wanting to revisit this. And, and she's only seeing her son one day a week with no overnights. So she has extremely restricted visitation. And meanwhile, in Mr. Geraldo's own filings and the motions that he filed for the court that he thinks is supportive of showing that he's a good parent, there's adult diapers with feces that he and his wife are posting on social media. It's really despicable behavior. And by no means, Your Honor, am I saying that my client is blameless. I have done due diligence of trying to get caught up in reviewing this very extensive case, and I agree with you 100% that this is an obscene amount of litigation and there's concerning behaviors throughout the case by both parties. But I just feel that there's very concerning behavior by Mr. Geraldo with how he's handling himself on social media, just how he's approached his pleadings. He seems very unstable. And the drug use, and so I just feel one day a week with Ms. Gultierrez is quite low, and so that's what brought us before the court here. And Alicio we can proceed with evidentiary hearing. I was really pushing to have some additional visitation with Ms. Gultierrez under the circumstances with Alicio turning 16. I don't know the last time I haven't seen anything in the last few years of this case. And I believe this was when Judge Gentile was the judge on the case, but Molly Rosenblum was appointed as guardian ad litem, and that was back in 2018. And there are notes in the 2018 proceedings from I believe October 29th that Alicio said he wanted to spend more time with his mom and actually preferred being with his mother during the weekdays and his dad on the weekend. And then we've had the additional information come forward of DACs of their adult daughter indicating that there's a lot of drug use and alcohol abuse by both Mr. Geraldo and his wife and physical acts against the children. So that's really where we're coming from. I just feel that a day a week seems extremely low for visitation with mom given both parties' behaviors in this case.
Mr. Geraldo, what's the problem? Why shouldn't she have more contact? Don't regard your motion. Answer my question. Your motion is filled, and your exhibits are filled with things from 2018. I'm not interested. Tell me today, given your son's circumstances, why it's not in his best interest to spend more time with his mother.
She doesn't leave the kids out of the litigation. Like, all all I really wanted to do was co-parent, and
That, sir, is a bald-faced lie. That is a lie. You have never tried to co-parent. This case has 58 pages of litigation, and that's just the title of your documents. Understand, when I'm referring to the amount of litigation, I have 58 pages telling me just the name of the documents that have been filed in this case. Do not suggest that you have attempted to co-parent with her. Tell me why it is not in your son's best interest to spend more time with his mother.
Okay. Well, the reason why we're here is because she had my daughter lie on her affidavit. That's why she tried.
We're here because you two have a complete inability to put your children first. Answer my question, not the one that you want to answer. Why isn't it in your son's best interest at almost 16 years old to spend more time with his other parent?
Number one, he's on a strict diet still. He's on a strict diet still.
He's also 16 years old.
He's on a strict diet. Right now, he's in the best condition that he's been. Like, he's very happy. He's very stable. He's getting good grades. He's playing on a football team. We work out together. I have a home gym in my garage. He's very stable. He's very happy. He gets home-cooked meals. He takes his medication every day. He drinks only water. He's very stable and consistent. When he goes on Saturdays, it's like his cheat day, which I don't approve of, but there's nothing I can really do when he's not with me for 8 hours. I encourage him to stick to his diet, and I tell him it's not a cheat day. You still got to follow everything, but it's clear and undeniable that they go out to buffets every time they post it.
There's nothing about that that's clear. You show me where that is clear, and I'll consider that argument. There is nothing about what you've represented or presented to the court about the current circumstances that make what you are alleging clear.
In Aliana's affidavit, it states that he is able to eat whatever he wants now. That's not true.
Okay. Well, if your son at 16 years old doesn't know that and is not capable of making his own decisions, then quite honestly, Ms. Gultierrez is the least of your problems, because he is in no position to emancipate to an adult if at 16 years old he doesn't understand the consequences of the choices he's making. And continuing, frankly, to prevent him from experiencing those consequences, you're not doing him any good. That, frankly, is not good parenting, in my opinion. There has to be a point in time where it becomes his responsibility, not yours, not his mother's. Right? If it's not 16, is it 17? And if it's not 17, is it 18? And if it's not 18, is he going to live with you for the rest of his life so you can continue to make choices about what he should and shouldn't put in his mouth?
All I know is that it's the court's responsibility to make sure that he's safe, and due to the, circumstances surrounding this case, I mean, how can, I've done everything in the best interest of my child's health. Right now he's stable because he's been with me primarily.
I don't know that. We don't have anything to compare it to.
Oh, yeah, this has already been proven in Judge Gentile's court, through Judge Gentile. This is on record.
He was 14 years old or 12 years old. Understand what the court is telling you, sir. Your position is unreasonable. The fact that you won't even consider that is unreasonable. At 16 years old, the fact that you think maintaining this level of control over your son, health issues or no health issues, is unreasonable. There is no way he will be a successful adult if you think the only way to keep him healthy is for you to monitor every single thing that goes into his mouth and that nobody else is capable of that function. Are you on medication currently, right this minute as we speak, because the court's making a note on the record that you are slurring your words?
That's incorrect, Your Honor.
I'm asking you. You didn't answer my question.
Drug test right now. I will leave the job and take a drug test right now.
How quickly can you go to ATI?
On me completing a drug test negative, then this cannot go on anymore. Okay?
Yes, it can.
Geraldo has proven over 4 years, for a treatable condition. This was not a hereditary condition. Unjustifiable pain and suffering. Okay.
I don't know, sir, I don't know how you expect your son to have a relationship with her, a positive one that has a positive impact on his life, if you refuse to let it happen. The court is making temporary orders today that mom will have Saturday to Sunday overnight every week. Dad is to submit to ATI today. When can you attend ATI? Give me a deadline.
I object, Your Honor.
I understand. I'm not listening to your objection, sir. I've read everything. I don't need to continue to allow you to argue the same things. I'm asking for a reasonable response to my questions. I'm not getting it. Tell me when you can submit to your drug test at ATI.
Right now.
Actually, I'm not going to take time out of my work day. I'll go take a drug test when I get out of work.
When is that?
I get out of work at 2:30.
Okay. So at 3 o'clock.
There's no, Your Honor, hold on, please, 1 second. I need to
negative
speak.
drug test.
I submitted a negative drug test.
Can we, is there someone else present? Can we have that on the record of who else is speaking?
Who else is in there, sir?
Your Honor,
Who's in the car with you?
my wife is in the car with me. My wife of 9 years is in the car with me. She had to bring the computer so that I can do this while I'm at work.
She doesn't need to sit in the car with you.
Tell
me what time. If you get off of work at 2:30, when can you be at ATI?
Before it closes?
I need a specific time.
Okay, Your Honor.
Alicia said he didn't want.
Listen to me. Your wife needs to step out of the
I'm
car.
listening to you.
She's not participating in this hearing. She needs to get out.
Emotional trauma. Tell us what Alicia said. She told him that the case was reopened. She told him that.
Yeah, so.
Answer my question. Don't tell me what you want to tell me. I've asked you a specific time. You will go to ATI today.
Before it closes, I have a company truck. I have to drop it off at the office. Then I have to get picked up and go to ATI.
So when is that going to happen? That's what I'm asking you.
Before it closes, Your Honor.
When does it close, sir?
I'm assuming 5. I'll have to Google it and check.
Okay. You'll be there at 4:30. That's the deadline to submit to urine and hair test. Mom's overnight visitation will start this weekend.
No, Your Honor.
And the court is going to interview your son.
Good.
What do you, Your Honor? This is going. You have I don't know if you know, like, well, obviously you don't know everything that's gone on. Okay, so how does the mom get to abduct, number one, abduct my children, which is a category D felony. Number two, withhold.
She's still talking to you.
Your Honor.
You are disregarding the court's directives, sir. I understand your arguments. I've asked your wife to leave the car. She's still talking to you. Where is she talking to you from?
She's out of the car.
Out of the car, close the door, stop participating in the proceedings.
Okay.
I don't want to hear her. If we were in court, sir, she wouldn't be talking to you. This is a proceeding that's going to happen in court going forward so that I have cooperation from you. I'm not listening to your arguments. I've made my order. You will submit
can listen to her argument, but you can't listen to mine?
I'm not listening
How
to
is that even
anybody's
fair?
arguments.
I have sole custody, not sole, but primary custody for a reason. She only has 8 hours for a reason, Your Honor. So you cannot just go and change. Just like you said, you need to have
I'm making a temporary order.
hearing.
Listen to me.
You're
Stop talking
hiding.
over me. Future proceedings will be in person in this matter, period. I'm not going to have this argument with you. Future proceedings will be in person. I've made my orders. I'm making a temporary order pending evidentiary hearing that expands mom's visitation to something that is patently reasonable for a 16-year-old, even one with your son's health issues, and the history in this case, of which I am very familiar. You will receive an emailed referral to submit to hair and urine testing at ATI by 4:30 p.m. Your failure to do so will presume or lead the court to presume that the test would be positive. The court is ordering the child to be interviewed. I'm setting a return hearing date on that interview, and from there, we will set further proceedings.
Your Honor, I'm not done talking, Your Honor.
Sir, I'm not listening to anybody.
You heard counsel speak, and you let her say everything she needed to say, so I need to speak and say everything that I need to say.
You have 3 minutes.
And you need to listen, Your Honor.
Excuse
You
me,
didn't give her a time
sir.
limit. You did not give her a time limit. How are you going to give me 3 minutes?
Because I didn't let her talk indefinitely either. I'm not having this argument. End of proceeding. I'm not having this argument. Prepare an order,
We just need
please,
time.
counsel.
Yes, I just want before we go off the record to make sure we have times for the exchanges and who's responsible for transport and location.
I'm also sending the parties to FMC. Mediate. As fruitless as I believe that may be, hopefully the parties understand. What time is your client asking for the exchange?
I believe
She gets them what time on Saturday?
What time, Ms. Gutierrez, is 8 a.m. or 9 a.m. okay?
9 a.m. works fine.
How do you get him now?
I pick him up. The order does state, though, that the other party's supposed to pick up and drop off, but I just figured it would be easier for me to go ahead and pick him up and drop him off.
What time do you pick him up currently?
10 o'clock.
You'll pick him up at 10 o'clock, and you will return him Sunday at 3 o'clock.
Thank you, Your Honor.
Thank you, Your
The
Honor.
parties will go to FMC, the child will be interviewed, we will come back, the court will receive Dad's drug test results. If a minute order needs to be issued as a result of those drug test results, then the court will issue a minute order. Let me get a return hearing date, please, on the child interview. Hang on, Madam Clerk, I'm checking that schedule.
I can go before then.
That's the
No,
two.
I just wanted to be sure. I wanted to see where it was relative to the holiday. I wanted to be sure that this court would be the one hearing the case. That will be for the return from FMC. Again, the parties will be referred there to mediate. Any questions about the court's temporary order for visitation?
No, only a question about the return hearing. Is that to be in person, Your Honor?
All hearings going forward will be in her person.
Okay, thank you, Your Honor. Oh, and you would like me to prepare an order for today?
Please prepare an order resulting from today's hearing. The referrals to FMC and Dad's drug test referral will be emailed to both parties.
Thank you, Your Honor. No further questions.
Thank you.